Then you have to hit it again when you don't want to speak.
Yeah, you don't want to pick up your little side comment.
Well, that's never. That's
Okay,
never.
we're live and recording.
Okay, I'm going to call this meeting to order. This is the Tuesday, February 13th meeting of the Marina Advisory Commission. And we always...
Is your mic on?
Is it on?
No.
Oh. Sorry. Anyway, just called the meeting to order. Everyone's here except for Ryan Bradley. Ryan is working now, which is an unfortunate happenstance for this committee.
So you have an update on
Oh,
Yeah, Ryan actually, because of his new job at Boeing, has resigned. He can't make it here to the meetings on time, and he's not sure which shift he's going to be working once his training is completed. So we're
Okay.
actively seeking a new member.
all right. And I'd like to welcome Barbara Arms, who is new to this committee, not to this dais, as a city council person that's drawn the short straw and has the responsibility of meeting with us on a regular basis. So welcome, Barbara. We start off our meetings with public comment. And I don't see any members of the public here, but do we have any online or other input?
No, we don't.
Okay. We'll close the public comment period and move on to our regular agenda. The first thing on the agenda is to review the adopted ordinances and bylaws, and I assume everybody's had a copy of those and enough time to work
Oh, we
them
have to
over.
review
Oh, I'm
the
sorry.
minutes first.
Approval of the minutes of our November 13th meeting.
Yeah, I move that we accept the minutes as submitted.
Okay, it's been moved and seconded that we accept the minutes as submitted. All those in favor? Say aye.
Aye.
Okay, any opposed? No, hearing none. It's approved. Okay, public comment, we already addressed, and there is none at this point. Now, the discussion, action, and presentation of the adopted ordinances and so forth, we all got copies of those, as I said. Any questions by the members of the committee?
Ken, I had a question about the, I understand the need to regulate the composition of the board, but I'm drawn to two Marina Advisory Commission members that shall be residents of the city and non-customers of the marina facility. I'm struggling to understand why that would be beneficial to this community or to this committee, and why it would be beneficial to the city to have people who have absolutely no idea about what takes place down at the marina as members of a sitting committee.
Okay, who wants to
Okay.
address that?
Sabrina Combs, Executive Services Administrator in the Mayor's Office. So the idea there was, as we are working towards engaging with the public, we're doing a lot of projects with the marina development, dredging, things like that. We're going to be engaging with the public more, having them involved. We wanted to make sure that more of the people who may not be using the marina on a regular basis are included in the process, and that they're included on this board that is discussing those items. So it was just about involvement and engagement and making sure those people are included in those discussions. Does that answer the question?
No.
Okay.
No. Go ahead, Brian.
Well, I was just going to say that I think it does make a little bit of sense to me, at least for the future, because up until now, we've been totally self-supported organization. I mean, all of the costs to operate, and even the capital costs of the marina, have been borne by the tenants, and so I don't think it made any sense for a non-marina tenant to be on this commission. But if indeed, and we don't know for sure yet, but if the city is going to be committing some funding for capital improvements and so forth, then I think it might make some sense.
Further comments?
I mean, I could see Byron's point, but, you know, I fail to see how a non-marina tenant has any interest whatsoever in the dredging of our marina. That boggles me, and maybe you can expand on that in a way that makes sense.
Well, I would say their involvement is in the sense that as you guys are doing projects in the future, and that included, it brings in more people to the marina. It brings in your larger boats. It also opens up some of our opportunities for economic development. So all of those things are factors. And you also want to have more people in the community knowing that the marina is open to them. I was at an event a couple months ago with the former mayor, and somebody walked up and said, I just don't know that the marina is a place I can go to. We want to make sure that people know that the marina is a space for them. It is available for them to utilize. There are great programs like the salmon rearing program, the hydros for here. You know, there's all these programs that are going on with the hydros, other things, and those programs are growing. And so we want to get the community more involved. And again, it is true that as we're investing more in the marina, we want to make sure that the community is involved in that as well. So there is an opportunity here to engage with them and have them be part of the process.
Chris, did you have a comment?
Yeah, I think that Sabrina's right on. For years and years, as Byron said, we've been self-sufficient and we've governed the marina ourselves being the marina tenants. Moving forward, we're looking to get out of that box and we're seeking funding from the city. I also think that in the past years, you know, we've been in the box as we've made our decisions. Now bringing in two fresh objectives that maybe aren't marina savvy, but they're business savvy or maybe they're community savvy. I think it can only add to the decisions we're making and add to the input and add to the discussions from a different point of view than one that we currently may have. And I'm not saying the one we currently have is right or wrong, you know, but I think that it does add to the committee and will make it better and stronger through added discussions and new topics that are brought up. And we're going to learn from that what the community feels like the marina is. And maybe we have a deficiency there and we can change that. So I think it's really going to add a new flavor to this committee.
Thank you, Chris. Typically, it's not just this commission, but most council meetings and so forth, there is no participation from the public and so forth. So good luck with, you know, trying to add two interested parties in the community. And I'm kind of a wait and see kind of person. You know, I think we can benefit from outside opinions and so forth. The thing that concerns me, and I guess that can be controlled from the chair at most times, some committees that I've been on in the past, every time there was a new person, they wanted to start over again with whatever it was. And, you know, we've got projects ongoing that take, you know, maybe 3 years of planning. Shouldn't take that long, but it does. And that part is, you know, it'd be difficult to tell somebody that, yeah, your input is valued, but don't talk right now, you know. Anyway, so we'll see how it shapes up. But right now, I understand that the major moving focus is to make all of the commissions and, well, it used to be committees and stuff, but commissions look alike and use the same rules. Is that the overriding concern or situation?
Yeah, we were working towards a standardization so that it's easier to follow for the community when they're looking at these documents. They understand the rules and the information that's presented for each of those boards. And right now we focused on our external boards, advisory boards, and now we're starting to work on the internal later this year.
When you were approached by a member of the public about what's going on and so forth, did you get their name? Can you add them to the list?
We didn't for that one. I happened to just be at an outdoor event, and what I told them is that we were working towards doing some changes because at the time we were starting the process. And I said, you know, please keep an eye out, and if you're interested, we'd love to have you participate in the process in the future. Because if these things go through, because at that time we hadn't finalized all these things with council, then there would be an opportunity for you to participate more.
Did you get a sense that that member of the community would participate at some level?
I think so, yeah. They seemed very interested. They were also interested in hearing more about the marina projects that were coming. And so we let them know that in the future, because again, this was months before we did it, we'd have an open house and some other events. So I think there's more interest from the public coming up.
Okay, Chris, do you happen to have names of people that, of the general public, that people that are not tenants of the marina that are interested in joining this committee, just offhand?
I do not at this point. I know that we did receive one application recently, but I believe there was a tie to a boat owner there, the spouse of one of them. So haven't been able to investigate that yet.
All right, we will be soliciting names from the committee of people that we know have expressed, I guess, some interest in joining. I have one name that I can contribute, but after I speak to that individual.
Well,
Go ahead,
the
just follow.
process
No,
would be
no.
for them to go online and fill out an application on the website, and then it comes to Sabrina and myself, I believe, maybe Mikhail. And so, yeah, the more people we can get interested, the more people we can get to complete that application, the better. So if you do know people, that's great. That's awesome.
So they need to complete an online application that is then considered by the administration?
Actually, it's the mayor's decision. This is the mayor's commission.
So that hasn't changed.
No, not at all.
And we all know that we serve at the interest of the community and certainly the mayor, because that's the mechanism that whereby we all ended up in these seats. Some of us a long time ago. But, okay. Any other questions relative to the membership term? Did the terms of membership or on this commission, were they all included going forward? I mean, like myself, I think my term was about up, and now it's a 2025, I believe.
On page 21, she has the update of the terms listed in the packet.
You got an extension.
I didn't, yeah. Oh, boy.
And remember, we did talk about that in the meeting, I want to say it was a couple months ago, where we highlighted that if there's a need, there is an opportunity, the way that we wrote this language, so that if you needed to be extended for a large project that was being worked on, that we could have that discussion. So we did make sure to provide that language.
Okay. Any questions about terms or anything?
I think the biggest consideration you guys may want to be aware of is just when you're going to change the date of a meeting, that you probably want to plan ahead for that or cancel the meeting or do a special meeting. So just understanding that, because the way that we advertise meetings and tell the public about meetings, we need to make sure that we do that in advance. So we have a calendar of meetings that are listed, and then if you want to make changes, that we just, as much as possible, do that in advance.
Yes, we understand, and this is actually a special meeting. And it was advertised as yesterday, up until recently on the city calendar. So, yeah, we will assist in trying to keep our ducks in a row and stick to our schedule as much as possible. But usually it's something terribly important like a college basketball game or something that causes us to change our schedule. But those things are scheduled as well, so we can anticipate those and still accommodate the members of the commission as needed. Any other questions, comments, or input or anything on the?
There's no action on our part on this, is
No.
there?
No. In fact, the bylaws have already been approved by city council,
Oh.
correct?
Yeah, city council already approved them. We're just waiting for them to be added to code publishing. They were submitted. We're just waiting for them to be included.
Okay.
They sometimes take a little bit of time to update the code, so just so you know.
The next number here is the election of chair and co-chair. I don't have, particularly now that this chair is new to me, I don't have any particular vested interest in that position, but I have talked to JJ, and he has been willing to stand as vice chair, and I would be willing to stand as chair until whatever happens, happens. Are there any applications or nominations from the floor?
Move the nominations be closed.
Okay, it's been moved. Is there a second?
Yeah.
Seconded.
Been moved and seconded that the nominations be closed. All those in favor say aye.
Aye.
Opposed, nay. I'm not sure that, I think we just closed the debate. We didn't, or closed the report of the nominations. We probably still need a vote to select a chair and a vice chair. Is someone willing to make that nomination? Someone other than JJ and I?
I move that Mr. Hewlett remain as chair and Mr. Jones be vice chair.
I'll second that.
Okay, it's been moved and seconded that the selection of chair and vice chair are as announced. All those in favor, say aye.
Aye.
Opposed, nay. Okay, the motion carries. That was a close one.
I know,
Yeah. Setting of the annual meeting schedule, I think, is pretty much rote at this point. Our best guess, anyway, would be the second Monday of every month, barring any changes that we have to make for participation and so forth. Does that still work for you? Oh, and minus the summer months, June, July, and August, I think.
Yes.
Is that correct?
Our meeting schedule moving forward for the remainder of the year would be March, April, May, September, October, November, and December. Having said that, if we do have the need for a meeting in June, July, or August, we would call a special meeting.
Very good. Byron?
Yeah, I've always been a little bit uncomfortable with the fact that we, when the marina is most active, and that is in the summertime, we don't have meetings. And to me, I think it would behoove us to have at least one summertime meeting at some point.
We
And
still have the option of declaring a special meeting.
Yeah.
Are you suggesting that it be part of the schedule?
Yes, that is what I'm suggesting, and we also have things, like, yeah, I think we have a deadline where we have to, if we want a rate increase, where that has to happen, and you may have to correct me, but I think the rate increases usually happen in the fall, is that correct? And then, so if we're doing the groundwork for a rate increase, we have to get all that done before May, which doesn't really make any sense to me.
The rate increase is scheduled to occur on October 1st. The rate increase is scheduled to occur on October 1st of this year. So if you did want to review them, potentially we could do something. July is a super busy month for us. Maybe either in June or August, late June or August. I think from a staff point of view, perhaps August would be the best. There seems to be a little bit of a lull at the beginning of August. Like the second Monday may work fine. And that would give August to discuss those and September to discuss those before they go into place on October 1st.
Right, as it stands now, the schedule is pretty much like I stated earlier, right? So,
That's right.
are you suggesting that we need to add a month?
Yeah, I guess, should I put that in a motion? I would like to move that we add the month of August for a meeting date.
Okay, is there a second?
Yeah, I'll second that, certainly.
Okay, it's been moved and seconded. Is there further discussion?
Chris, is there any reason why we should not be able to meet in August that you can think of?
No, I think that may work out just fine. We just need a quorum. So as you consider this, think about your own traveling plans for that month as well.
I'm okay in August.
Good point.
I'm not gonna be okay in May, but I'm gonna be okay in August.
Okay, it's been moved and seconded that we add an August meeting that I'm assuming would be again on the second Monday of the month. And if there's no other discussion, we'll take action on the motion. All those in favor say aye.
Aye.
Aye. And opposed, no. Okay. Motion carries. I think we're due now for the general update, Chris, on the marina activities.
Actually, we have two videos for your viewing pleasure.
Oh.
One is titled Open Public Records Act, and the other is Open Public Meetings Act. So we were going to make some popcorn, but we ran out of time.
How long do those last?
15, 20 minutes each.
Oh, okay. And that's why they're right in front of us here, these screens?
38.
So they're 30 and 18 minutes exactly.
Okay,
48 minutes of my life.
We will not be darkening the room.
okay. So let's get it started.
These are part of the training you've done in the past. We're just ensuring that everybody is fully trained. Gabe hasn't been trained yet, so we thought this would be a great refresher for these two trainings that you have seen in the past.
You're required to take it.
Hello, I'm Assistant Attorney General Morgan Damerow. This training provides an overview of the Open Public Meetings Act. It's intended for both the public and public agencies. Our purpose in this training is to provide a greater understanding of the legal requirements of the Open Public Meetings Act. The Act was passed in 1971, a time of a nationwide effort to make government affairs more accessible and more responsive. The purpose of the Act is to provide the public access to information concerning the conduct of state and local government. The law is based on the principle that open government is essential to our free society. The Open Public Meetings Act gives the people of Washington State the opportunity to witness the deliberations and decisions of government. More recently, that's included an opportunity to provide public comment as part of that process. Multi-member governing bodies of state and local agencies such as school boards, city and county councils, and the state commissions must comply with the Open Public Meetings Act. The law states that it is intended that the actions of these governing bodies be taken openly and that their deliberations be conducted in an open manner. Meetings subject to the Act must be open to the public, gavel to gavel, unless the law permits a meeting or part of that meeting to be closed. Thank you for watching, and I hope you find this training informative. This training's purpose is to increase your knowledge of the Open Public Meetings Act. The OPMA is in Chapter 4230 of the RCWs, and this training incorporates updates from the 2022 legislative session. This training video contains 15 short segments. We just discussed Section 1, the history, and Section 2, the purpose of the Act. The remaining segments we will review the scope of the OPMA, what is a governing body, what is a meeting, what is action and final action, travel and gathering, regular meetings, special meetings, remote meetings. We'll also talk about executive sessions, public attendance and comment, minutes, liability, as well as other laws and provide some additional resources to assist you. The Act has several clear requirements, and compliance with them is improved with training. Training can mean the difference between meeting your agency's OPMA obligations and expensive litigation. The Act applies to governing bodies of multi-member public agencies, both state and local. At the state level, public agency includes state boards, commissions, committees, departments, educational institutions, or other state agencies which is created by or pursuant to statute. Public agency does not include the courts or the legislature. For local governments, public agency includes any county, city, school district, special purpose district, or other municipal corporation or political subdivision of the state of Washington. Examples of these include city councils, county councils, school boards, and fire district boards. Public agency may also include a sub-agency of a public agency which is created by or pursuant to statute, ordinance, or other legislative act. A good example of these includes planning commissions, library or park boards, or commissions. A final group is any policy group whose membership includes representatives of publicly owned utilities formed or pursuant to Washington laws when meeting together or as or on behalf of participants who have contracted for the output of generating plants being planned or built by an agency operating them. In some cases, an entity which is not an agency may still be subject to the OPMA when it is the functional equivalent of a public agency. This determination depends on whether it performs a governmental function, receives governmental funding, the extent of governmental involvement or regulation, and whether the entity was created by government. Some activities of public agencies are not subject to the OPMA. They include certain licensing and permitting activities, quasi-judicial matters, matters governed by the Washington State Administrative Procedures Act, and certain collective bargaining activities. All meetings of the governing body of a public agency shall be open, and the public and all persons shall be permitted to attend any meeting of the governing body of the public agency, except as otherwise provided in the OPMA, such as during a declared emergency. A governing body is defined as a multi-member board, commission, committee, council, or other policy or rulemaking body of a public agency, or any committee thereof when the committee acts on behalf of the governing body, conducts hearings, takes testimony, or public comment. Agencies governed by an individual, such as a single director, are not subject to the OPMA. Meeting means meetings at which action is taken. Physical presence of the members is not required. A meeting can occur by phone or in some cases by email. I will talk more about email exchanges later in this training. A meeting does not need to be titled meeting. The OPMA also applies to retreats, workshops, and study sessions. In order for there to be a meeting, there must be a quorum of the governing body. A meeting does not occur if there is no quorum. We have talked about the fact that the OPMA applies to a governing body at a meeting. In order to qualify as a meeting, the governing body must take action. Action means the transaction of the official business of a public agency by a governing body, including but not limited to receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final action. A subset of action is final action. Final action means a collective positive or negative decision or any actual vote by a majority of the members of a governing body when sitting as a body or an entity upon a motion, proposal, resolution, order, or ordinance. Final actions must occur in public. Secret ballots are not allowed. A majority of the members of a governing body may travel together or gather for purposes other than regular meetings or special meetings, so long as no action is taken. And remember, action includes discussion of agency business. This means a quorum of members can travel to a meeting together, or they can gather at a public or private event, such as a festival or social function, so long as they do not collectively discuss agency business or matters. In the next segments, we are going to talk about the types of meetings where a governing body may meet. The first is regular meetings. Regular meetings are recurring meetings held in accordance with a periodic schedule by ordinance, resolution, bylaws, or other rule. State agencies file these notices of regular meetings each year with the Office of the Code Reviser. Regular meeting agendas are to be posted online on an agency's website 24 hours in advance. A special purpose district or city or town is not required to post an agenda online if the agency has an aggregate valuation of property in the taxation district of less than 400 million, a population of less than 3,000, and provides confirmation to the state auditor when filing its annual report that the cost of posting notices to a website would exceed 1/10 of 1% of the agency's budgets. These provisions exempting very small agencies changed in 2022. Certain notice requirements are required for special meetings. These include written notice 24 hours in advance of the meeting, provided to members of the governing body unless waived. The notice must be provided to local newspapers, radio, and TV stations that have a request on file with the agency. The notice must also be posted on the agency's website if it has a website. There is an exception for very small agencies, agencies with no FTEs or with no one whose job responsibilities, either by job description or by contract, with the responsibility to maintain or update the agency's website. The notice must be prominently displayed at the main entrance site and the meeting site unless the meeting is being held as a remote meeting or one where some or all members of the public are limited due to a declared emergency. The remote meeting provisions are new, and we'll be addressing those in just a moment. The notice must specify the time, place, and business to be transacted. Unlike regular meetings, where the agenda may be changed and final action taken on a matter which was added to the agenda, under special meetings provisions, the governing body is prohibited from taking final action on any issue not on the original notice. There is an exception to the notice requirement for emergency special meetings. Those are meetings involving injury or damage to persons or property, or the likelihood of injury or damage, where time requirements make notice impractical and increase the likelihood of injury or damage. New in the OPMA through the 2022 amendments are provisions addressing a governing body holding remote meetings. After the declaration of emergency by a local or state government or agency or by the federal government, and the agency determines that it cannot hold a meeting of the governing body with members of the public in attendance with reasonable safety, the agency may either hold an all-remote meeting without a physical location or hold a meeting with the governing body present but some or all of the public excluded. In either of these instances, the agency must provide an option for the public to listen telephonically or by using a readily available alternate means in real time, such as an available television cable broadcast or the internet. Any option selected may not require any additional cost to access the program. If the agency does not provide an option, the agency is prohibited from taking action except for an executive session as authorized under the OPMA. If your agency is holding an all-remote meeting with some or all of the public excluded, the notice of the meeting must include instructions on how the public may listen live to the meeting. An agency that held some of its regular meetings remotely prior to March 1st of 2020 may continue to do so with no declared emergency, so long as the agency provides an option for the public to listen as required for emergency remote meetings. Up to now, we've been talking about all the requirements to ensure openness and transparency. Under the OPMA, there are enumerated instances where the governing body may convene outside of the public's view in executive session, or if the governing body is discussing matters not subject to the OPMA. An executive session may occur as part of a regular or special meeting. The grounds for holding an executive session are limited to the purposes listed in the OPMA and are narrowly construed. The purpose of the executive session and the time it will end must be publicly announced before excluding the public, and the time can be extended by further announcement. Examples of purposes include certain real estate transaction discussions, reviewing negotiations on publicly bid contracts, evaluating the qualifications of an applicant for public employment, and meeting with legal counsel regarding enforcement actions, litigation, or potential litigation. The OPMA provides a list of authorized executive session purposes at RCW 4230-110. An agency must carefully follow the law when meeting in an executive session. For example, when meeting in an executive session under the OPMA to discuss agency enforcement actions, litigation, or potential litigation, there are 3 requirements. First, legal counsel representing the agency must be present. Second, the purpose is to discuss an agency enforcement action, litigation, or potential litigation to which the agency, governing body, or a member acting in official capacity is a party or is likely to become a party. And finally, public knowledge regarding the discussion is likely to result in an adverse legal or financial consequence to the agency. Remember, an agency can discuss only those matters in an executive session under the OPMA that it has told the public it would discuss. The members cannot talk about other topics in that executive session. In addition to an executive session, a public agency can have a closed meeting to discuss matters not subject to the OPMA, such as deliberating on a quasi-judicial matter or collective bargaining. Other laws may provide additional procedures or authority for particular meetings or hearings to be closed to the public. There may be additional laws for particular agencies as well. As we discussed, all meetings of the governing body of a public agency shall be open in public, and all persons shall be permitted to attend any meeting of the governing body of a public agency, except as otherwise provided in the OPMA. An agency also cannot place conditions on attendance, such as requiring persons to register their names or fill out a questionnaire before attending. This provision does not prohibit any generally applicable condition determined by the governing body to be reasonably necessary to protect public health or safety, or to protect against interruption of the meeting, including a meeting at which the physical attendance by some or all members of the public is limited due to a declared emergency. As noted, email or phone call discussions amongst members of a governing body can be a meeting under the OPMA. But the purpose of the OPMA is to permit the public to attend and observe agency meetings. So when the public is unable to attend email or phone call discussions that are meetings under the OPMA, the act has been violated. Recent amendments to the OPMA make it clear members of a governing body can participate in meetings remotely with no declared emergency. However, public attendance must be maintained. In doing so, it is generally agreed that public notice procedures must be satisfied, and the agency has to set up a process for the public to attend, such as a speakerphone available at the agency's official meeting location, so the public can hear the discussion. In contrast, since an email exchange amongst a quorum of the members of a governing body is not open to the public, such an exchange in which an action is taken is a meeting that would violate the OPMA. And remember, action is broadly defined. It is very difficult to envision a way in which those email exchanges comply with public notice or attendance requirements for a regular or special meeting. One of the 2022 changes to the OPMA is a requirement that public agencies receive public comment at or before every regular meeting at which final action is taken. The 2022 amendments allow agencies to accept public comment either by written format or orally. If the governing body chooses written public comment, it can be submitted before or at the meeting. Any written comment received must be distributed to the governing body. The governing body may set reasonable deadline for submission prior to the meeting. The oral comment option is very similar to what many agencies were doing voluntarily before the 2022 amendments. Agencies can put reasonable procedures in place to allow for public comment. This may include limits to the time available for public comment or limit comment to those topics on the agenda. However, a governing body may also choose to accept public comment on any topic. If oral public comment is taken by the governing body, it shall, when feasible, provide an option for remote public comment for individuals that have difficulty attending. Difficulty attending may be due to a disability, limited mobility, or for any other reason that makes physical attendance difficult. A governing body is not required to accept public comment that renders orderly conduct of the meeting unfeasible. The OPMA has procedures for dealing with disruptions where orderly conduct of the meeting is unfeasible. The minutes of all regular and special meetings, except executive sessions of such boards, commissions, agencies, or authorities, shall be promptly recorded, and such records shall be open for public inspection. The OPMA does not require an audio or video recording of a meeting. Many agencies choose to do so. Public agencies are encouraged through the 2022 amendments to make audio or video recordings of meetings, or to provide an online streaming option of all regular meetings of the governing body, and to make any recordings that the agency does make available online for a minimum of 6 months. Violations of the OPMA can result in a lawsuit against an agency and its members. A court can impose a $500 civil penalty as personal liability against each member who knowingly violates the OPMA, and a $1,000 penalty for a subsequent knowing violation. A court can also declare any action taken at a meeting not held in compliance with the OPMA null and void. And a court will award costs and attorney's fees to a successful party seeking a remedy under the OPMA. To recap, this presentation covers the highlights of the OPMA. Public agencies may be subject to other laws governing other particular meetings, hearings, procedures. Some agencies have particular laws that govern their meetings as well. Like the OPMA, the laws concerning agency meetings and hearings can also be amended from time to time, Therefore, agencies are cautioned to be mindful of all current laws concerning their meeting and hearing procedures. Thank you for watching the Attorney General's OPMA training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Open Public Meetings Act. An official should first consult with its agency's counsel for routine assistance and training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Open Public Meetings Act.
Hopefully, the city staff has seen this and would qualify for a one and done kind of thing, you know. I see some smiles, but no comments.
No, we do watch it, those of us who are involved in the meetings, and that's what Mikhail and the city clerk, Julie Nestor, are trying to make sure that we're all getting it, all the advisory boards and those staff that are watching, so.
Okay. Yeah, it's interesting that the courts and legislature exempt themselves from this Open Meeting Act. That's kind of interesting. Any questions or anything directed to staff? Hearing none?
There's another one, right?
Yeah, you have one more. And
Yeah.
I do have a Robert's Rules cheat sheet.
Oh,
If you ever
okay.
want it, I'm happy to provide it in quick
Yeah.
reference.
Well, let's proceed on to the next training.
This is Mikhail. To let you know, this one is a bit longer.
Hi, I'm Bob Ferguson, your Attorney General. With me in this video is the Open Government Assistant Attorney General, Nancy Creer. This training video provides a basic overview of our Public Records Act for both records requesters and state and local agencies. It's intended to provide a greater understanding of the legal requirements around the Act. The Public Records Act is a law created by an initiative vote of the people in 1972, which provides the public access to the records of government agencies. It received 72% of the vote. The purpose of the Act is to provide the public full access to information concerning the conduct of government, mindful of individuals' privacy rights, and fulfill the desire for the efficient administration of government. The law is based on the principle that open government is essential to a free society. All state and local agencies must comply with the Public Records Act. All public records must be disclosed unless a law exempts records or information. There are well over several hundred exemptions. Some of those exemptions are listed in the Act, but many exist in other state and federal laws. The Act is a broad mandate interpreted in favor of disclosure, and its exemptions are narrowly construed.
This training presentation is based on the Public Records Act and the Attorney General's Advisory Model Rules. The rules are online at the Attorney General's website at www.atg.wa.gov. They provide examples of steps to comply with the Public Records Act. An agency may adopt any part of the model rules into its own rules. Local agencies should consult the model rules when establishing local Public Records Act ordinances. The model rules provide comments that are useful for interpreting the Public Records Act and for training agency personnel. The model rules are non-binding, but they are based on extensive outreach, court decisions, and have been cited favorably in some court cases. This training video was prepared in the fall of 2017. The model rules were being updated in 2017. The legislature also amended the Public Records Act in 2017, and the legislature can amend it again in the future. The courts can also interpret the Act. Consequently, and as a reminder, there may be developments in the law after this video is prepared. Several updates on the law are often posted in materials on the Attorney General's office website on the Open Government Training page. A PowerPoint on that page also provides training on the Public Records Act. This training video contains 16 short segments where we will review history, purpose, and intent of the Public Records Act, scope of the PRA, general obligations of an agency, what is a public record, requests for records, initial agency responses, reasonable estimates, adequate searches, disclosure, electronic records, managing broad requests, exemptions and withholding, fees, other records provisions, liability, and finally, additional resources. You have just heard from the Attorney General about the history, purpose, and intent of the Act. The Act regulates the disclosure of public records. The Act requires disclosure of public records unless a law permits withholding of a record or part of a record. The Act has many components, and compliance requires training. Training can be the difference between a satisfied requester and expensive litigation. The Act applies to both state and local agencies. A state agency includes every state office, department, division, bureau, board, and commission. A local agency includes every county, city, town, municipal corporation, special purpose district, and other forms of local government. In some cases, an entity which is not an agency can still be subject to the Act when it is the functional equivalent of an agency. This determination depends on whether it performs a government function, receives government funding, the extent of government involvement or regulation, and whether the entity was created by government. Courts are not subject to the Act. Agencies must appoint a public records officer responsible for being a point of contact for the public and for overseeing compliance. The name and contact information of the public records officer should be published with information on how to submit requests for records. The public records officer must have received training on the Act within 90 days of assuming his or her duties. Agencies must also publish information on the agency organization, rules, and procedures, and an index of specific categories of records. Agencies are required to adopt reasonable rules to provide full public access to public records, to protect public records from damage or disorganization, to prevent excessive interference with other essential functions of the agency, and to provide the fullest assistance to inquirers. Agencies may wish to consult with their attorneys when developing their rules and procedures. A public record is any writing relating to the conduct of government which is prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. It could be an email, text message, paper, letter, or memo, an audio or video recording, a picture, image, map, or any recording of information or data compilation from which information may be obtained or translated. A public record is not just what an agency creates, but includes documents created by citizens or private companies that are used or received by a government for a governmental purpose. A public record may also include documents not possessed by the agency, but which were used by the agency. For example, the courts have described that work documents on the personal computer, personal cell phone, or personal email account of an agency employee or official are subject to a request under the Public Records Act. Records of certain volunteers are excluded from the definition of public record. Records are excluded when they are not otherwise required to be retained and are held by volunteers who do not serve in an administrative capacity, have not been appointed by the agency to an agency board, commission, or internship, and do not have a supervisory role or delegated agency authority. Any person wishing to inspect or copy public records of an agency should submit the request to the agency, preferably in writing, using the agency's request form. The Public Records Act doesn't prescribe any official format for a valid request, So an agency must honor valid requests for identifiable records regardless of the format of the request. While using an agency's form is not required, it is typically the most efficient way to submit a request. A requester who chooses not to use an agency form must give the agency fair notice that he or she is submitting a request for public records. Agencies are required to honor requests received in person during an agency's normal office hours or by email. If an agency has adopted reasonable rules on how requests should be submitted, the agency may rely on those rules. The agency should be helpful to the requester in explaining how a request should be submitted and to whom. Records shall be available for inspection and copying upon request for identifiable records. So requesters should give a reasonable description of the records, enabling the agency to search for potentially responsive records. A request for all or substantially all of an agency's records is not a proper request for identifiable records. A request regarding a particular topic or containing a particular keyword or name shall not be considered a request for all of an agency's records. A request for information is not the same as a request for public records. The Public Records Act does not apply to requests for information. There is no duty to create a record that does not exist in order to fulfill a request for records or information. However, requests for information are at times easier to fulfill. Fulfilling a request for information may avert a large public records request. An agency must promptly respond to public records requests. Within 5 business days of receiving a request, an agency must respond. An initial response may be any one of the following: acknowledging receipt of the request and providing a reasonable estimate to respond, or fulfilling the request, or providing an internet address and link to the records on the agency's website, or seeking clarification while also, to the greatest extent possible, providing an estimate of time for further response if the request is not clarified, or denying the request with an accompanying written statement of the specific reasons. Reasonably clear requests for identifiable records may require no clarification. However, some requests are unclear. Seeking clarification permits the agency to identify responsive records, which in turn will aid in determining the scope of the request. Clarifying a request provides the fullest assistance to the requester so that the requester receives and pays for only those copies that are desired. Clarification may also result in prompt disclosure by identifying only those records desired. An agency should not seek clarification if the request is for identifiable records and is reasonably clear. If the entire response is unclear and the requester fails to respond to the agency's request for clarification, the agency need not respond to it. However, the agency must respond to those portions of a request that are clear. An agency may deny a bot request, which is a request that was automatically generated by a computer program or script when it is one of multiple requests from the requester received within a 24-hour period. The agency must establish that responding to the bot request would cause excessive interference with other essential agency functions. A requester is typically not required to provide the reason for a request, unless a law necessitates additional information from the requester. Agencies and requesters are encouraged to promptly communicate with each other if there are issues regarding a request. An agency's initial response to a public records request must provide a reasonable estimate for the time to respond when more time is needed. A reasonable estimate should account for many factors, including the time to have the requester clarify the request if needed, as well as time to assemble and review the records, provide notice to affected persons or agencies if needed, to redact exempt information, and to create a withholding or exemption log. An agency should not use the same estimate for every request. Rather, each reasonable estimate should be based on factors such as the complexity of the request, other pending requests, agency resources, and other agency essential functions. It's a good practice for an agency to briefly explain to the requester the basis for the estimate in the initial response. Extending the estimate is appropriate when circumstances have changed or additional information has come to light. Agencies are encouraged to briefly explain the need to revise an estimate. An agency bears the burden of showing that its search was adequate. Consequently, agencies should be able to document how a search was conducted and, for example, what search terms it used, as well as the location searched. An adequate search depends on the facts of each request, but it is one that is reasonably calculated to uncover all responsive documents in whatever form, paper or electronic. An agency must make more than a perfunctory search and follow obvious leads as they are uncovered. The search should not be limited to one or more locations if there are additional places where responsive records are likely to be found. If responsive public records are likely to be found on or in an agency employee's or official's personal device or account, the employee or official must search those devices and accounts for responsive records. It is possible to conduct an adequate search and still not locate a responsive document. However, if a responsive record is not located and/or if challenged in court, the agency will have to prove its search was adequate. An agency must make records available during its customary office hours for a minimum of 30 hours per week. Public records are presumed to be open for inspection and copying unless a specific law exempts the record or information from disclosure. Agencies can deliver copies of records to a requester in a number of ways, such as providing links to the records that are on the agency's website, providing paper copies of paper records or scanned copies of paper records by mail or making them available for pickup, or providing electronic records by various methods. You may recall that with respect to what is a public record, the Public Records Act does not distinguish between paper and electronic records. Most agencies create records in an electronic format. A copy of an electronic record should be produced in the requested electronic format if reasonably feasible. Translating a record into an alternative electronic format at the request of the requester, or scanning a paper record, is not creating a new record. Metadata is information embedded in a document that provides detail about the document's characteristics. This may include information such as when the document was created, edited, recipients, and so forth. Non-exempt metadata must be disclosed when expressly requested. When agencies obtain new technologies, they should consider not only the agency's business operation needs, but also records retention and disclosure requirements. Examples of such technologies are portals through which records can be requested and delivered, electronic redaction tools, or retention software, just to name a few. In addition, agencies can look at whether they could make use of their current technology more robust. The legislature encourages agencies to make public records widely available electronically, particularly commonly requested records. For example, an agency could make commonly requested records available on its website. Then, as noted earlier, an agency could fulfill its obligation to provide access to a public record by providing a requester with a link to a specific agency webpage containing the electronic copy of the requested record. For requesters without access to the internet, an agency could provide a computer terminal at its office. Agencies should develop policies addressing technology concerns, such as if and when agency employees may use personal devices for public agency uses, and what responsibilities and requirements therefore attach to the employee. An agency may receive a broad request that asks for any and all records related to a topic. Agencies may not deny a request solely because it is overly broad. As noted, a request for all or substantially all of an agency's records is not a valid request. But a request for all records regarding a particular topic or containing a particular keyword or name is not a request for all of an agency's records. After an initial search shows there are potentially hundreds or thousands of different types of responsive or potentially responsive records, a public records officer should contact the requester to explain the estimated total number of records that would need to be searched, or provide other information describing the anticipated scope of the search. Then the agency could seek clarification to ask if the requester wants all of the different types of responsive records and is willing to pay for all the copies, or instead if the requester is seeking only some of the records. Good communication can assist both the agency and the requester. A broad request will usually result in a longer estimate of time for disclosure, as well as producing records in batches or installments. When seeking clarification, to the greatest extent possible, the agency must provide a reasonable estimate of time the agency will require to respond to the request if it is not clarified. In many instances, a requester will narrow the scope of the request to enable the agency to provide disclosure more promptly and less expensively. An agency may manage broad requests in a couple ways. An agency may require a deposit in an amount not to exceed 10% of the estimated cost of providing copies for a request. If an agency makes copies in response to a request available on a partial or installment basis, the agency may charge for each part of the request as it is provided. If an installment of a records request is not claimed or reviewed, the agency is not obligated to fulfill the balance of the request. Finally, use of electronic technologies to search, review, redact, and disclose public records can reduce overall costs of compliance for agencies. Agency responses denying in whole or in part inspection or copy of any public record shall include a statement of the specific exemption authorizing the withholding of the record and a brief explanation of how the exemption applies. Exemptions exist throughout the Public Records Act and other state and federal laws. Common exemptions include information such as personal information in files maintained for agency employees, if private, pending investigative files compiled by law enforcement or agencies with authority to discipline members of a profession, the non-disclosure of which is essential to effective law enforcement or for the protection of any person's right to privacy, educational records of students in public schools, attorney-client privilege information or work product related to litigation, or protected healthcare information. There is no statute providing a general privacy exemption. If privacy is an express element of a specific exemption, it is only invaded if disclosure would be both highly offensive to the reasonable person and also not of legitimate concern to the public. Exemptions in the Act must be construed narrowly. The general rule is that an agency redacts or withholds only the exempt information and produces the non-exempt information. An acceptable way of providing this information to the requester is with a withholding index, often called an exemption log. The information provided as part of the log should include a description of the type of record or part of record denied. The description should include identifying information from the document. For example, whether the document is a letter or email, the date the document was created or other relevant date, the total number of pages, and the sender and recipients. The exemption log must also include the statutory authority making the information exempt and a brief explanation of how the exemption applies. Some of this information will be evident on the face of the document where redactions have been made to only part of the document. An exemption log, the written explanation, also may be provided in different formats. For example, may be handwritten or compiled in a spreadsheet or chart, or in a letter, or redactions are marked on the records with exemption codes, and the requester is given the key to the codes. The format of the exemption log or exemptions is not relevant so long as the required information is provided. Any person may inspect non-exempt public records for free. An agency may not charge for the time of staff to search, review, or redact public records when preparing them for inspection. If a requester wants copies of records, an agency has options to charge for copies. It can charge actual costs, or it can charge default fees listed in the Public Records Act, or it can charge an alternative up to $2 fee for an entire request. Some other provisions may be relevant too. In order to charge actual costs, an agency must make available for public inspection and copying a statement of the actual per page or other costs and how it determined actual costs. An agency may adopt its statement of actual costs only after providing notice and a public hearing. When calculating fees, the agency must use the most reasonable, cost-efficient method available to the agency. Staff time to copy and deliver the requested public records may be included in an agency's costs, but an agency may not include staff salaries, benefits, or other general administrative or overhead charges unless those costs are directly related to the actual cost of copying the public records. An example of when an agency may want to charge for the actual costs of staff time is where an agency scans paper records and copies them into an electronic format. The charges should be reasonable and related to the wage of the person likely to be repeatedly assigned to this task. If an agency does not have staff available to make copies, for non-exempt records, an agency may send a scanning or copying project to an outside vendor and pass on the actual cost to the requester. Electronic copy costs may include the actual cost of the electronic production or file transfer of the record, the use of any cloud-based data storage processing service, and the cost of transmitting electronic records, including the use of a physical media device. A second method to charge copy costs is for an agency to choose to use a statutory default fee schedule provided in the Act. In that case, an agency need not calculate actual costs if it has rules or regulations declaring the reasons doing so would be unduly burdensome. The statutory default fee schedule lists, for example, per page costs for paper records, scanned records, and costs for electronic records. As yet another alternative, an agency can assess an up to $2 flat fee for an entire request when certain conditions are met. The Act includes other fee provisions. For example, an agency cannot charge for access to or downloading of records it routinely posts on its website prior to the receipt of a request, unless the requester has specifically asked that the agency provide records through other means. An agency may impose the actual cost of a customized service charge when the request would require the use of IT expertise to prepare data compilations, or when such customized access services are not used by the agency for other business purposes. The agency must notify the requester and take other steps if it chooses to do a customized service. An agency can require an advance 10% deposit before making copies. An agency may enter into a contract, memorandum of understanding, or other agreement with a requester for an alternative fee arrangement, or in response to an extensive or frequently occurring request. An agency may choose to waive any charge pursuant to agency rules and regulations. Upon request, an agency must provide a summary of the applicable charges before making copies. The requester then may choose to revise the request to reduce the number of copies and the cost. In sum, the Public Records Act provides an agency several options for assessing charges for copies. The choices selected may vary from agency to agency. Under a different law, the records retention laws at RCW 40.14, agencies must maintain a log of public records requests, including for each request, the identity of the requester if provided, date of receipt, text of request, description of records produced, description of records redacted or withheld and the reasons for doing so, and the date of final disposition. With respect to the identity of the requester, it is possible an agency received only an email address from the requester, and if so, that address would be included in the log. The logs must be retained per the agency's records retention schedule and are a public record. The records retention law also provides that agencies spending at least $100,000 to fulfill requests during the prior fiscal year must report 17 data points about their PRA requests to the Joint Legislative Audit and Review Committee. Under the Public Records Act, any person having been denied an opportunity to inspect or copy a public record may seek further review in the agency. The person may also file a lawsuit to enforce his or her right to access public records. A requester can also file a lawsuit if he or she believes that an agency has not made a reasonable estimate of the time or of the charges to provide public records. Such a lawsuit is to be filed in a court within 1 year of an agency's final definitive response to a request, such as a final claim of exemption or the last production of public records on an installment basis. The agency has the burden of proof to demonstrate that public records were lawfully denied or its estimates were reasonable. If it does not make this showing, an agency will pay the requester's reasonable attorney's fees and costs and may pay potential penalties for denying records in violation of the Public Records Act. A court will consider mitigating and aggravating factors in determining a penalty amount. Lawsuits for public records can be extremely time-consuming and expensive for agencies. Understanding and correctly applying the law is a good risk management tool for state and local government. In rare cases, individual employees may also be civilly or criminally liable under other laws. State agency employees and state officers are subject to the Ethics in Public Service Act. It is a violation of that state ethics law for a state employee or officer to intentionally conceal a public record required to be released under the Public Records Act. State agency employees and officers may be fined up to $5,000 per violation of the state ethics law. It's also a crime for any agency officer to willfully mutilate, destroy, conceal, erase, obliterate, or falsify any record of that agency's office, except where the law expressly authorizes the non-disclosure or destruction of records. The crime is punishable by imprisonment of up to 10 years or a fine of up to $5,000 or both.
Thank you for participating in the Attorney General's Open Government Training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Public Records Act. An employee should first consult with its agency's public records officer for routine assistance or training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Public Records Act. Thanks again for watching.
There's no quiz.
Chris, I'm going to pick on you to wake us all up here to a general update on affairs in the, that was the wrong choice of words, but, yeah.
I got one thing for you.
Oh, okay.
You get a prize.
Just, I know that's a lot, and yes, you've seen it many times. But the points to take away strongly are that asked the question if anyone knew what fees it would cost. And it could cost the city up to $100 per page per day if it's not provided. So those fees and penalties can add up real quick, and they're not covered by any of our insurance authority or anything like that. So it's real cost to the city. So those are just a couple things to take away. And then I have your certificates you can fill out. You've done it for 4 years. So if you guys pass those down, you can sign them and give them back at the end, as well as staff too.
We will provide magnets if you'd like to put them on your fridge.
Okay, thank you.
Oops. Gave you something else. There's one for Byron. There's one for Byron.
Yeah, I was just reading what this other thing is here. does this form belong to somebody? It's not hidden, it says, fire bond.
It might have been on the copier, he'll just pass it to
Oh,
you.
okay.
Might have been-
I'll just drop it off on the way out.
oh, sure.
Everybody got one?
Okay, so thank you for going through that, thank you for enduring that, it's super important. And you did get a certificate at the end, so maybe it was worthwhile. So the staff is super busy these days, we're busy working on the marina, we're busy working in the office, and we're busy preparing for the summer. This weather that we've had is provided us great opportunities to do stuff that we normally can't do this time of year, and it's been pretty amazing to watch. Some of the big projects that staff's working on are pile hoops, capping pile. These are things that we couldn't normally do. We're doing some cement work around the marina. We're working on the DACWA contracts and the DACWA program, getting over that hump. And then we're also writing some grants, which is pretty cool. As we move forward, we're looking at the summer. We're already sold out for Labor Day. That's exciting. We've got some big events coming that we're starting to get some traction on, such as the Oak Harbor Youth Sailing Wildcats National Regatta, May 17th and 19th. That's super exciting. We've had one boat actually make a reservation to stay the weekend. We suspect there'll be more, so that'll be a neat event. Hydros for Heroes, that is also sold out. I don't know if you've heard, but that's turned into the West Coast Regional Races. We can expect about 100 boats for that. It's going to be a big event and a lot more people. And then we have the Would-Be Summer Classic, July 26th through 28th, which is just now starting to heat up a little bit, so we'll see how that goes. So those are really the big events that we're working on at the marina. There's so much going on. One of the sad notes is that we did suffer some storm damage in that windstorm. F3, one of the southeast patio walls broke free, so we let that go down to the bottom until we're ready to fix that. And then at the end of E-Dock, our Bryan and DR just past that last large pile right in that area there. The brackets that hold those docks together, one of those broke. We'll be able to fix that in-house, and we have the parts on order and anticipate doing that in probably the next month or so. We'll need an extreme calm day to fix that. Other than that, through that storm damage, we survived well. We didn't receive any other damage to the marina, to the roofs, to the docks, anywhere else. So this mild winter is really paying off for us, and we think that hopefully if it stays on, we're going to be ahead of our maintenance and repair schedule compared to where we are this time of year, which will help us out doing other things around the marina. We're going to start pressure washing very soon, which will be nice to get that done and out of the way. We're going to dive deeper into cement than the little patches we're doing. We're going to do some big patches. So we're going to do some painting and just kind of all kinds of things going on there. So lastly, just to reintroduce Barbara Arms. She's going to be with us, city council member. This is her first term on the city, and she's thrilled and excited to be part of the Marina team. I can tell you that. So be happy to answer any questions.
And Ken, I'll provide just a quick update on a couple of things. Sorry. So we did get the USDA cooperative service agreement signed to conduct wildlife damage management. That's just activities to control nuisance species at the marina. And Chris mentioned we're working on a couple of grants. So just to highlight two of those. One is the local community project budget request. Representative Clyde Shavers is the sponsor of that. So we're asking for $1.03 million for marina dredging in match to the county's $1 million. And then we're working with our federal relations firm, Crossroads Strategies, on an application for the Infrastructure Investment and Jobs Act development program for port infrastructure development, which also applies to intermodal connections as well as marinas that aren't ports in certain conditions, for a $30 million ask that would require a $6 million local match by the city We're asking for 12 million for the dredging and 18 million for the breakwater. And as we look back on similar awardees, we're actually fairly optimistic about that. So Crossroads Strategies did a site visit with us. They came in, toured around the marina. Chris took them out into the harbor. We talked a little bit about the breakwater, went out there and looked at some of the damage that happened in the last storm event. Council did have a retreat workshop yesterday with department directors and redid some of their priorities. The marina was tied as number 2 on city priorities. It's also included in with recreational facilities, which is one of the things it tied for, as well as the CDA, the Central Development Area, is included. The marina is included in that, which was the number 1 priority. So marina is very high up on city council and the mayor's list of priority projects that they want to get done. So you see that reflected in a lot of the efforts that we're doing and all the things we're sucking Chris into with trying to go after some very large amounts from both state and federal funding assistance.
Yes, thank you. Any questions by the commission?
I have a couple
Okay.
of notes. Brian, you indicated there was an $18 million ask for the breakwater. Is that, you did say
Yes,
that?
that's correct, yeah.
And is that to replace the existing breakwater with a similar type breakwater? Or are we talking
They don't make a
rocks?
similar type breakwater anymore.
No, I didn't think so.
Yeah.
But are we talking rocks, or are we talking metal structure? What, is there a scope? Has that project been scoped yet?
No, it hasn't. We've been talking to Moffett Nichols, and I'll remind you guys to turn on your microphones. We've been talking to Moffett Nichols. They're our consultant that we're using for dredging and the light reconfiguration we're using. And we've learned a lot from them about breakwaters and, what you can and can't do, but we haven't really discussed what we're going to do here at the marina. We will start discussing that in the near future, kind of narrowing that down. We did get some dollar amount estimates from them in the ballpark back of the napkin thing, and that's how we came up with the 18,000. And then coupled with a new breakwater that I believe it's Port Orchard's getting, or up there, you could figure out the price per foot and then generate a ballpark figure for our marina as well. So
Have you seen the Port Orchard breakwater? Have you seen how they've done it?
no, I've seen pictures and drawings, but I haven't seen the
It's
actual
pretty
thing.
cool.
Yeah.
It really is.
So,
I have one more thing. Chris, did you have any reported boat damage from the windstorm? I know we had a little damage to the marina, but was there any boat damage?
there was one sail that came loose out on FDOC. Other than that, we didn't receive any reports. That doesn't mean it didn't happen. I can tell you that we picked up quite a few cushions and canvas things up out of the water during that, fenders, that sort of thing. But that's the only one that I'm aware of at this point.
Thanks.
Larry? Go ahead.
Yeah, Chris, I was just wondering, is there any way that the commission members here can be invited to some of those discussions with the Moffett Nichols, just so that we kind of know what's in the plans?
Yeah, I think we could do that. We would want to limit the number of people. We typically meet every other Tuesday at 10, but that schedule runs with what's going on in the project. Those are the dates we set aside, but they're not always. I would say that I would encourage like one or two of you at a time to log in, and we can provide that information just so you can be caught up on it.
Or at least, you getting us some detail on what's been discussed. Right?
Sure. That is kind of a segue to the next meeting. We just finished up the feasibility study, and that was going to be one of the agenda items on the next meeting.
Okay. Any other comments or questions from the commission? Okay, well, moving on to the advisory commission comments. JJ?
Yeah.
Go ahead.
I'm actually going to push the mic. Chris, I have a few. One is, and I apologize for doing this after the fact. I should have come to you first before it actually took place. But I think the DACWA deposit thing caught a lot of people by surprise. And I'm not quite exactly sure why that was done. But, you know, if those, you're probably familiar, 20 some odd years ago, 23 years ago, apparently I made a $200 deposit for my slip 24 or 23 years ago. That money was refunded to me. Then I got another bill for the additional 500 or whatever it was. So in 2024, I'm effectively going to be paying 13 months mortgage instead of 12. And I guess my concern is that we probably should have discussed it, how we were going to do this. Are we going to do this again next January? Are we going to refund deposits and do more and collect a greater deposit next year? I'm kind of at a loss to figure out why we would do that.
Okay, so backing up, when we did the original contract last February, you did pay a deposit that went with the slip. The deposit is equal to 1 month's rent. Moving forward to this past February, all of those contracts expired and we had to issue new contracts, which means the deposit went with the contract in the person, but it didn't transfer to the new contract. So that's the way we did it. That's why your deposit went from $200 to whatever it is, $450 or whatever it was. Moving forward, we've set the new contracts up in a way where we can alter the dates of the contract. So for example, when the contract ends October 31st of this, or excuse me, January 31st of next year, we'll be able to change that date, which means that you're going to be within the same contract, which means you won't need to redo a deposit. It'll just sit there the way it was. The way we've set it up is once the contracts are nearing an end, say the beginning of January, we're going to email everybody and have them either respond with, yes, I want to continue on my current contract, or no, I'm giving 30 days notice. We'll then put that into your DACWA file, so essentially that's a renewal of your contract. We won't have to go through this process again. And that's why we kind of set it up a little funky this year, also staying within the constraints of DACWA. So to answer your question, no, we're not going to do the big contract thing again next year, and no, your security deposit won't have to be renewed. It's just going to be there from now on till the end of time, similar to when we used the Marina program.
Was this just only for boats that were on a 12-month contract and not month-to-month?
Yes, that's correct. That's correct. The month-to-month ones remain the same. They never have an expiration date until you give us 30 days notice.
And so they have a deposit, but the deposit just keeps running?
Yeah. And that's the direction we've moved the annual contracts into
Well,
now.
I mean, that puts the annual contracts at a disadvantage. That's not the idea. I mean, because we've just added an extra month of payment.
But you received an extra month in refund as well, or a portion of it.
We received a portion of a month.
Yeah,
refund.
yeah. That's
Yeah.
just the price difference is a
Well.
difference. So moving forward, it'll be a little different and similar to the way that we've done it historically.
Yeah, well, it doesn't make sense to me. I mean, the way you're doing it going forward makes a lot of sense. I mean, that's the way
Yeah.
it should be done. But it means that all the people who are on a yearly contract for the last year have paid a little extra that they shouldn't have been obligated to pay.
Chris, perhaps you can prepare for the next meeting a discussion about DACWA, what it is and what it isn't. There are lots of questions that I've received from tenants. I guess their supposition was that I knew what I was talking about, but that's certainly not the case.
Sure.
But, yeah, there are lots of questions about administratively what decisions were made and how or if DACWA is capable of handling a typical tenant situation going forward.
Yeah, it's the pet subject of mine, but, you know, we discussed at our last meeting with the issues about DACWA were brought up, and Chris said that he was trying to address those. And I tell you, for 2 months, I was in relative DACWA bliss for the December and January billings went off perfectly. You know, I got the statements, I paid my bills, got a receipt, everything jived. And then this last month with the deposit and all that was just it was the worst one ever. I ended up writing 5 different checks and got 13 emails in 11 days. And among the 5 checks was after I'd paid everything, I got another a $3.47 bill for electricity. So it's just, it's not working, and I think we've either got to talk about making some big changes or dumping the system. It's just, and everybody the last thing I would do would be submit my credit card to them, because their billing is so bizarre that I think anybody that has given them a credit card really ought to be paying attention to what they're being billed and what they're paying. And one other thing, and this is probably the most important thing to me, is you know, I'm paying thousands of dollars a year for my Marina mortgage, and I cannot get a statement of my past billings and my past payments. It's impossible to get. And there's no other thing that I pay. Bank card statements, all that stuff. You can go online and you can always get a report of what your payments and what your billings have been, but can't do it with DACWA.
I think that what might be helpful for the next meeting is if each of you could email me your major concerns, rather than me just trying, you know, I know what a lot of them are. I've talked to all of you. Rather than me just kind of doing a blanket summary of DACWA, I'd much prefer to kind of capture the concerns and then address the concerns directly and see what we can do moving forward.
At one point, if I remember correctly, DACWA was in the midst of a major change to their software. Can you give us an update on that?
Yes, that was an interesting situation. So when we raised the rates in November, I believe it was, at that same time they rolled out a new version. So we were kind of in a precarious situation of trying to get the rates implemented while at the same time learning and dealing with this new version. The new version has had several updates since then, believe it or not, and they're trying to enhance it and improve it every day. We feel like some of the things they've done are really good. However, there are some things that are a struggle for us as well. So, you know, I'm anxious to get some feedback from you guys and then address it at the next meeting in detail. You know, where these questions and concerns are and what Doc was doing, what we're doing, that sort of thing.
I have 2 other.
Okay, go ahead.
Chris, I have 2 other issues.
Sure.
One is, and I've asked this question before, and I'm not sure that I'm comfortable with the answer is, do you have enough staff, is my question, is and hopefully you'll smile at that question.
Yeah.
I'm very concerned when I see a staff go to 410s instead of 8-hour shifts, because I was in production my whole Navy career, and 25 years in the Navy, and for 15 years after that in the civilian world. And in my own experience, and every metrics that can be measured tells me that 410s is the least efficient way. Employees love it, but it's the least efficient way to get it. Hours 7, 8, 9, and 10 are incredibly unproductive. So I was wondering why you went to 410s, and whether you need another person full-time, because you're out there, Elise is by herself sometimes, or Duncan or Danny, they're by themselves, and they have jobs that you have scheduled for them or that they can't complete by themselves.
So I'll answer your second question first. Do I need another person? I can tell you that marinas our size have double the work staff that we have. I can also tell you that most of them are port districts with almost an unlimited revenue source. Yes, I need more people, but we are not a port staff. We're an enterprise fund, and this is what we can afford right now. We actually have more staff now than the marina had for many, many years. When I first started working here, there were 4 of us. Now we're at 5, and in talking to Dave Williams, he fought hard to get to 5, and then something happened, and he ended back at 4, so it was a short dance with 5. But yes, we always need more people, and before I jump into the second part of that question, you know, we're pretty fortunate to have the staff we have, the people we have. You know, they're extremely hardworking, they're extremely talented, and they actually really care about the end product of the work they do. They're not out there trying to produce as much work as they can, they're trying to produce as much quality work as they can, and there's a big difference there. The 410s, we feel like the 410s are a bonus to the marina. We feel like it makes us more productive actually and allows us to complete more projects. Most of the projects we do are not typically single day projects. They're multiple day projects or multiple weeks or even month projects. This allows us to really dive in, get a hold of the project and work on them, especially in the summer when we have seasonals, uninterrupted. You know, we love to talk to you guys. We love to talk to the tenants, and quite frankly, customer service is the most important thing we do at the marina. That's what separates us from a lot of marinas. But we also have some projects to do, be it cement, pile hoops, pile caps, whatever we're working on at the time that we try to get done. The reason that we went to the 410 is, one, you're right, employee satisfaction. That's a key thing. Getting 52 extra days off a year is pretty special. But secondly, and most importantly from the marina's point of view, is we were able to expand our hours. Previous to that, we were running 8 to 5, 6 days a week in the winter, 7 days a week in the summer. Now we're open from 7 to 6. And I can tell you that a lot of our guests and many of our tenants have enjoyed that. No longer is there a huge rush to, in the morning at the fuel dock, to go catch Deception Pass Current or the slough or whatever. But people can really plan it out and they know we're going to be there. Granted, our hours say the fuel dock is 7:30 to 4 or 5:30 now, but we tell people if you're there at 7 when we show up or even earlier and you're paying with a credit card, we'll come down and take care of you before we even go up to the office. So I think there's been a huge boon in customer service going to the 410. I think the employees like it better. And I think that we're actually accomplishing more with the staff we have. Now, true, maybe with some other staff say they wear out and get tired, but our staff seems to really enjoy it and accomplish a lot of work. They're pretty busy running all over the marina continually.
A question was posed to me about you personally being there 410s and not there the other 3 days.
Yeah. That question has come to me, and I can tell you that I've made myself more than available to the staff on my days off, not only the staff of the marina, but the city staff and the tenants as well. We're going to move forward with the summer schedule here pretty quick, and my days off will switch from having Friday off to Monday off, which will allow me to be there on a more busier day, which will be nice for the marina, I think.
As someone who has a full-time job, the time that I'm at the marina is usually from noon to 1 or after 5.
Yeah.
So it is often that if I want to talk to one of you at lunch, that's not an option. I'd have to shift my lunch around. So that's just a comment about like the practicality of when you're open and when you're not, especially the office. I think 410s or whatever schedule you want to do is great to get people as effective as possible, but having people there when needed is the important part.
Yeah, the reason that so in the winter, we're closed from 12 to 1 for lunch, be it the fuel dock or the office, and that's been fairly successful. People have adjusted to that. The reason we do that is so that we can focus more on those projects out there. Everybody goes to lunch, and then everybody can get right back on what they're doing. Put more hands on projects, more condensed time working on them. So, but I do sympathize with you, and I understand that, and you can always call me. I am the most flexible person in the world, probably, as far as the Marina goes. Yeah.
I had one more.
Go ahead.
Actually, two more. If we are making some money, why don't you get another person? Is it are you being told no? Or, you know, have you asked to plus up the staff? I think that's, I would love to see you have more people, or as many people as we can afford to pay. I really do. I think that, I know you do an amazing job keeping that marina going, but you know what? We've seen it now where there'll be one person there for a two-person job. And,
Yep.
you know, if you had more folks, you could probably get more done. The second part, and I'll let you answer that in a minute, is I couldn't help but notice that there were an awful lot of race week people at some of our recent meetings. What do you know? And can we talk about any plans to try to have the race come back to Oak Harbor?
So the race week, it was nice to see Shalene. It was nice to see her. I hadn't seen her in a while. I think they were out just looking around, seeing what we're doing. You know, race week started there, and I believe that there's a hope and a vision that someday they could come back. I believe that. I know they're nestled well into Anacortes now, and she told me things seem to be going well there. But I think it was more of a scouting mission. What is Oak Harbor doing? What are they doing with the channel? What's going on with the depths of the marina? That sort of thing. Honestly, I chatted with them for maybe 10, 15 minutes, but it was nice to talk to them and get caught up. I had not seen them since then. And then, of course, seeing Gary, I see him every once in a while in the summer. You know, he's a big advocate for Race Week, and he's got lots of good stories.
Yeah, I talked to Shalene after that meeting too, and she's still, number one, Anacortes is not a great racing area, and I committed up there last year, and it just does not have the conditions that Penn Cove has. All the sailors know that. So from a racing standpoint, we're much better off, but Shalene is still, she still needs to have a way of launching small boats, and she still needs to have the entrance dredge to get the big boats in there. And that's what she said were her two main issues, and it doesn't sound like either of those things are going to happen in the very near future anyway.
There could be stuff going on behind the scenes with the channel and stuff, so we'll
Okay.
see how that unfolds, and I'll probably have more information for you at the next meeting on that.
Okay.
Chris, just as a point of information, when do your seasonal workers begin, and are there going to be seasonal workers?
Yes, that's a super exciting time of the year for me. We'll have one start in April, early April, and then the other two will start late April, beginning of May timeframe, just as we go through and interview people and select them. But yes, we're already starting that conversation and really excited to get them. They make a huge difference for us in a lot of things that we do that they do while they're here.
Is their attention focused more on the customer service, arrivals, departures, lending a hand, that kind of thing?
Yeah, they deal a lot with that.
What's their job description, I guess?
The job description deals a lot with painting, cleaning restrooms, washing docks, doing those sorts of tasks which allow us to do some of the more complicated, bigger projects. Don't get me wrong, we love doing we love talking to people. That's a huge part of our job, but we also want to fix things and stuff. So, yeah, they're more of the day-to-day, we call it shoreside and dockside type jobs throughout the day, keeping things clean, painted, looking good, working at the fuel dock.
Have you found that with the extended hours of operation, that you're either attracting more people or you're getting more people to pay for moorage, transient moorage, that sort of thing?
With the boats coming and going, yes, to all of the above. It can be kind of surprising if we take a stroll out there at 5:30 in the afternoon, you know, greet people like we like to do, so, yeah.
Yeah, I've, from where our home is, I can see boats leaving at 7:30 in the
That's
morning.
right. And we get there at 7.
Yeah,
So, yeah, we do go out there pretty much last thing of the day and the first thing in the
Okay.
morning.
good. Yeah, it's nice to have people utilizing facilities, but they need to pay for the privilege, so.
Yes, sir, that is correct.
Any other comments from the commission? Questions? Future agenda items. We talked about the Daqua situation and needing to get some more detail and explanations on that. And I do have a portfolio of a whole bunch of stuff I will share with you.
The thing that I would ask about that is don't copy each other. We just watched, 48 minutes of that stuff. Send it just directly to me.
No, you'll get it.
Yeah, but
And
I
some
need
of it's
something
hard
to build a
copy, so-
presentation off of,
Yeah.
so.
Yeah.
Yeah.
That's a wise thing to
And
say.
not make excuses, but build something that's worthwhile. So.
We've talked about additional potential members. We have a regular commission seat to fill now, perhaps, depending on what happens, what shift
Right.
Ryan is on. And in adding a couple people from the public, I would assume that anyone who has an interest in being a member of this commission needs to go online and fill out the form and so forth. And I believe it includes something about what's your level of interest, what's your expertise, what do you bring to the table, kind of thing. Hopefully that is a part of the process. And I'm speaking to whoever's listening, not necessarily you. I know you agree with me on that one. So we need a couple of members, and at least 2, and it may take a while to fill those unless we get interested parties that are willing to show up and participate. And I really appreciate Barbara being here, and she's signed on to be part of this group. And she'll, I've characterized it in the past to, it's like taking a drink of water out of a fire hose because there's so many moving pieces in this activity. Was there anything else, Chris, on your plate that you need to talk about?
I would just say that for the replacement for Mr. Bradley, if you guys know of anybody that's interested or want to talk it up on the docks, that's typically how we find a person for that is, I'll just be talking to people, or staff will, or you guys will. We'll also write an article in the newsletter, which is helpful. If we don't get any bites from that, we've talked about maybe even trying signage around the marina in the past. But, we've never had to get to that extent. Usually it's a lead that you people give us or one that we find on our own. As far as the public goes, I know that Michaela and Sabrina are working on that,
One person I thought of, Josh, he's attended a couple of the meetings. He's been to the open house. If you know who I'm talking about, he owns the indoor indoor golf range there on
Midway, or Pioneer,
yeah,
right by
Pioneer.
Ace.
Yeah. What's Josh's last name?
I can't remember.
Yeah, younger guy,
He's
but
tall, he's like
Yeah.
6'5".
He's interested in this type of thing, or?
he's been pretty active. He's shown up to all the open houses and has attended 1 or 2 of our MAC meetings previously as well.
Okay.
And he's
He's a Marina tenant?
he is. Yeah.
Okay, our next meeting is scheduled for March 11, and hopefully we can all make it there. Again, I'd like to thank Barbara for her attendance and attention, and encourage members of the public that are, if they're interested and feel like they can bring something to the table, to put their name in the hat for inclusion. I will collect these certificates. I guess we sign them and return them to you. Is that correct? Okay.
I want to put it on the refrigerator.
Well, we'll have some copies for you. Yeah. Anything else for the good of the order?
We're done.
Okay. We'll adjourn the meeting as of 4:50, and hearing no comments to the contrary, we're adjourned.
Thank you.